Hello, thank you for that introduction, Martin, and welcome everyone to the trademark section of the IP webinar update. So let's dive in. Let's talk about Brexit and the use it or lose it deadline of 31st of December 2025. So who is this relevant to? Well, the deadline is relevant to owners of comparable or daughtered UK trademarks. Now, those are the UK trademarks that were created by Brexit from the UK parent rights or from international trademarks which designated the EU. So why is this relevant? Well, it's relevant because if those daughtered rights have not been genuinely used in the UK, brand owners may run the risk of losing those trademarks via non-use revocation actions. So you may be thinking, most jurisdictions have non-use period. So what makes UK comparable or daughtered rights so different? Well, let's just do a little recap. So via the withdrawal agreement, comparable rights have enjoyed a 5-year grace period of use from the 1st of January 2021. Which meant that use of the parent EU trademark in the EU would support use and maintain the daughtered UK right and vice versa. So any genuine use of a daughtered right in the UK could be used to support use and maintain an EU trademark. This transitional period regarding genuine use for comparable marks ends on New Year's Eve, so 31st December 2025. So from New Year's Day, 1st of January 2026, any use of the EU parent right is not relevant and cannot be used to maintain or support use of a daughtered UK right. The relevant use market for that daughtered right will solely be in the UK. Both the UK and the EU trademark systems contain provisions for non-use revocation if the trademark hasn't been used for 5 years. But as I just said, in terms of future use requirements, UK daughtered rights must now show genuine use in the UK, and any EU trademarks must show genuine use in the 27 member states of the EU. Now, given that all daughtered rights are now 5 years old, we expect to see and we expect to challenge more trademarks via revocation for non-use. So, what should brand owners do next? Well, I put together some key takeaways. First thing you should do is conduct an audit of your UK and EU trademarks and identify any daughtered rights which are at risk of revocation via non-use. So you can easily identify these rights by their prefixes. They look different to normal UK trademarks. They will start with 009 if it's a UK right which has an EU parent, and the prefix will be 008 if it's a UK right where the EU was a designation of an international. So you're doing your audit. While you're doing this, consider, are the trademarks still commercially relevant? Are they fit for purpose? Is there an intention to revive the brand or recommence use? So we have seen an increase in heritage brand revivals of late. Consider whether the trademark has evolved. Will the trademark be used in the same format as you have currently got it registered? Have a look at the scope of protection. Is it broad enough to cover future plans for the brand? And consider whether any strategic refilings need to be made. In terms of collation of evidence, if you do find yourself on the receiving end of a revocation action, you will need to provide evidence of use. So it's good practice to capture and collate dated evidence of use of all your brands regularly throughout the life cycle of the trademarks. Penultimately, ensure your representation is up to date at the IPO. You will need a UK attorney to represent you. And finally, don't just look at your portfolio of rights. If you've got any third-party disputes on your hands, consider if any of those rights relied on can be challenged for non-use. And if they can be challenged, then challenge them. That concludes my piece on Brexit and the 31st of December deadline. I'm going to pass you on to Dan now for a piece on Skykick.
Thanks, Jane. Um, so we thought we would revisit one of the headline cases from 2024. And for anyone that tuned into our webinar last year in the trademark section, you'll remember that we looked at this in great detail. But this time we thought we'd have a look and see what impact that decision has had across trademark procedures in 2025. Next slide, please, Jane. So, as a bit of a whirlwind recap, just for anyone that's not familiar with the facts, Sky, of course, is the well-known broadcaster, and they sought to sue Skykick for trademark infringement, and they were a provider of email migration and cloud storage services. Um, as a counterclaim to that infringement, Skykick challenged Sky's registered trademarks on the basis they should be found to be invalid because they had obtained those registrations in bad faith. And they relied on a very specific argument in this context. And they said that Sky had registered its marks for such a broad range of goods and services, including many which it had never provided, and thus it lacked a genuine intention to use those registered marks for all of the goods and services that were covered. So effectively, this was an argument that Sky had abused the trademark system to obtain registered protection in marks for goods or services that really they were not entitled to do. Um, so skipping ahead to the decision, Sky were found to have applied for some of their trademarks in bad faith, again on the basis that it didn't have that genuine intention. And so the court narrowed the scope of those trademark registrations to more closely reflect the areas where Sky actually traded. And perhaps one of the key sort of quotes from the decision that summed up the effect of this was where the court said, where, however, the broad description includes distinct categories or subcategories of goods or services, such as computer programs and computer services undoubtedly do, then for the reasons we've given, the proprietor may be found to have acted in bad faith in relation to one or more of those. So effectively, they were covering wording that was so broad that it could capture a wide variety of things and far too wide for somebody to genuinely trade in all of those. Next slide, please, Jane. So the decision was long awaited, and everyone's really keen to see how the IPO itself would interpret the findings and how that would impact on the procedures for new trademark applications going forward, particularly where broad wording was to be used. I think many speculated that maybe we'd see a sort of sudden surge in refusal examination and maybe a move more towards the USA trademark system, where for those who may know, specifications of goods and services have to be worded much more tightly, much more narrowly, and you can't have as broad a wording as you can in the UK. It took almost 7 or 8 months for us to get any kind of indication from the IPO as to what they were going to do. So in June 2025, they finally handed down an updated practice guidance note, setting out the impact of the decision on their examination guidelines. I think overall, the general feeling for a lot of people was it was a bit of an anticlimax because rather than making any sweeping changes, there weren't any prescriptive imminent measures that were set out by the IPO. And indeed, in the note, they stated expressly that it's not possible to prescribe the exact circumstances where an examiner will intervene in circumstances where bad faith may arise in the specification. Um, However, the note was quite useful as a summary note on the law around bad faith, and it did give some indication as to situations where we can expect examiners to intervene. So some of those examples that were given, um, the only two main examples were one where broad lists of goods and services that cover all 45 classes, an examiner will likely raise a bad faith refusal, or two, another example they gave were specifications covering all goods in class 9 and therefore by extension a specification that covered all goods in one particular class. Um, it did confirm that examiners won't automatically object to broad terms such as computer software or clothing, but they did generally remind applicants that they should consider at the time of filing what is appropriate for their intended use. And so for some people who perhaps only have a very narrow commercial interest in the mark, rather than covering something broad such as computer software or clothing, a narrower subcategory might be more appropriate. So next slide, please, Jane. So we've had the guidance, but how has the decision actually impacted on some inter-party decisions? Well, we've had a handful that have referred to Skykick across 2025. So the first one I wanted to look at was a decision concerning an application for the mark Unite Faith Workers Fellowship. So this decision was handed down on the 17th of April, so actually prior to the examination guidance. And it had been opposed by Unite the Union on the basis of bad faith, because it covered a very broad specification of Class 35 services. And it's probably worth pointing out that in the decision, the specification itself spanned about 50 pages, just to give you an idea as to how broad they went in their coverage. Um, the bad faith opposition was upheld in its entirety, and they applied Skykick in their summation. But rather than following the sort of tact of the court in Skykick and only narrowing the specification down to the commercial interests of the applicant, they actually just refused the application in its entirety for all of the services. And so in issuing its decision, the hearing officer said, I appreciate that the applicant has not sought to register goods and services in every class. However, this does not mean that the specification cannot be unjustifiably broad, especially in light of the lack of any real explanation as to what it is the applicant does or intends to do. And I think that the final bit of that quote there is probably the key. The applicant was not able to offer up any kind of reliable explanation for why they wanted to cover those things in the application, and it went against them. Next slide, please, Jane. So second decision I wanted to look at involved Mark Energo, and this decision was handed down on the 9th of May. So a little bit different. This application covered quite a broad selection of classes, 13 in total, and I've listed the numbers there. And that at face value is quite a broad selection of commercial interest. And again, in the decision, this specification covered well over 100 pages, just to give you an idea as to how far they'd sought to protect their mark. The opposition involved numerous grounds, but again, bad faith was cited by the opponent on the basis they argued that the application had a broad specification and the applicant clearly had a dishonest state of mind. The IPO upheld the decision in its entirety and refused the application for all of the classes again. So again, going beyond the tact of the court in Skykick and choosing not to just simply narrow it. Overall, the decision of the IPO focused on a general refusal to accept that one single business would use a trademark for such a varied list of goods and services. So it really was the sheer scope of the specification that was enough to indicate that lack of genuine intention to use the mark. And once again, the applicant, they could not offer up any convincing explanation as to why they needed to cover all those classes. Next slide, please, Jane. So finally, wanted to look at this decision, which was handed down on the 12th of June, involving the mark CMVRG. Slightly different context to this one. It concerned an appeal to the appointed person of a previous successful opposition decision from back in 2023, which had succeeded on bad faith grounds. Now, just as a very brief bit of context, usually in these appeals, there really needs to be a sort of distinct and material area of law for the appeal to really stand any chance of being successful. And the applicant here argued that the decision should be set aside because the IPO had set the bar for bad faith too low in their decisions. But quite bizarrely, they didn't actually question any of the application of direct legal principles or fact by the hearing officer. So that made it very difficult for them. And that probably added to why the appeal failed overall. But it was notable that Skykick was still cited of relevance in the decision. And the appointed person said Skykick reinforced the importance of a satisfactory explanation for making a UK trademark application in circumstances where an inference that the mark was applied for in bad faith appeared justified prima facie. And it was notable once again that the applicant just could not provide any convincing explanation as to why it needed to cover the services that it did. Next slide, please, Jane. So what does this all mean? I think the key takeaways for anyone that's looking to protect their brand and register it with the IPO, it really does highlight the importance of having a genuine intention to use your mark. That has always been inherent in UK law, but I think Skykick, whilst not bringing any sweeping changes as of yet, has probably reiterated the importance of that underlying principle in the trademark system. I think practically it's sensible to avoid overly broad specifications going forward and really trying to tie your specification into your commercial intentions. And for anything that you do cover, make sure that you're prepared to fully explain why you've covered those things in your application if you're ever questioned on it. Bad faith is quite clearly, it has previously been, but going forward will likely be a very reliable ground for challenging the validity of broad scope trademarks. And so that should reflect in your filing strategies. So I'm going to hand back over to Jane for the next segment.
Thank you, Dan. So, excuse me, we're now going to consider the impact of audio branding. I'm going to illustrate and place some examples of registered sound marks, and I cover a case which has highlighted the protection of audio marks and the creation of a sound identity as an audio equivalent of the brand's visual identity. And at the end, I will provide you with some key takeaways on audio branding. So, when we think of trademarks, we tend to think of conventional trademarks such as words, logos, colours, etc. We don't tend to think of non-conventional trademarks such as sound, movement, holograms, etc. However, it is the non-traditional trademarks that do tend to make those news headlines. So, for example, I'm thinking of the Cole Palmer trademark application where he applied to register a movement mark for his Shiva goal celebration. Anyway, this talk is about sounds, and sounds have always been able to be registered. They just don't get the press, provided they pass the standards of registrability. So, for example, they have to be distinctive and can distinguish the goods and services of the proprietor from those of other providers. The sound cannot be generic, functional, or commonly used in industry. The sound must be presented in a way which is clear, precise, self-contained, easily accessible and intelligible. And the most common way of doing this is via an audio file or musical notation. This way, you've scoped out exactly what your rights are, which is important from an enforcement point of view. Is also helpful for third parties looking at the registers to see what is protected. So you will be aware of audio marks, for example, the well-known MGM roaring lion sound. And we're all familiar with Microsoft Teams, and you may be interested to know that the specific notation of the Microsoft Teams sound is considered part of the company's brand assets and is protected as a trademark. So I have got a couple of example jingles here. So here we have the iconic McDonald's 5-note I'm Loving It jingle, which is represented on the trademarks register as a musical notation. Next, we have got the Direct Line jingle, which is also registered in musical notation. Here we have Netflix Tadum sound. I'm hoping you can hear that. Which is registered as a daughtered right at the UK IPO as a multimedia mark. Oh, sorry. Don't seem to be able to move my slide forward. Just bear with. Okay, sorry about that. So the case that has made an impact and development for sound marks is a case brought by Berlin's public transport operator, BVG. Now they applied to register a short 2-second long sound mark in the EU. Now this application covered class 39 for transport, passenger transport, wrapping and packaging services, storage, and arranging transportation for travel tours. The trademark was rejected by the EU IPO due to it being devoid of any distinctive character. BVG appealed to the EU IPO's Board of Appeal, who found the sound banal and too short and simple to be recognised as an indication of origin, or in the alternative, that it would be perceived as a functional sound intended to draw the listener's attention to the subsequent announcement or to other aspects of the services covered. BVG appealed to the EU's General Court on the basis that the Board of Appeal did not correctly assess the characteristics of the trademark applied for. The General Court confirmed, firstly, the criteria for assessing distinctiveness for sound marks is the same for all categories of trademarks. And secondly, to be perceived as a trademark and indicator of origin, the sound should be identifiable as a trademark, and in this sense, it should not be functional. In the transport sector, use of sound is a common badge of origin aimed at allowing the general public to identify the goods or services of a company and allowing entities to create a recognizable sound identity. So, in respect of the banal and simple argument, the court held that the duration and simplicity of the audio mark are intended to make the sound memorable and indicate commercial origin of the services. Now, in respect to the functional argument, the court stated that the melody does not have a direct link with the services covered by the mark and does not appear to be dictated by technical or functional considerations, as it does not correspond to a noise usually heard when using transport services. This makes it more likely to be a brand identifier. The court concluded that even if the sound has a functional role, this would not prevent the mark from indicating the commercial origin of the covered services. So the court annulled the Board of Appeal decision, and BVG have now got a registered sound mark. So, in terms of takeaways, the BVG case confirms that short, simple sounds, so even just a sequence of a few notes, can possess the inherent distinctiveness required for trademark protection. This opens the door for brands to register audio cues, and companies may feel more confident in using audio branding as part of their IP strategy. The court's decision could mark a pivotal moment in audio and sound protection, which could lead to more innovative sound marks being registered across a range of different sectors. That concludes this part of the talk. I will now pass you back to Dan.
Thanks, Jane. So for our penultimate section of the webinar, we thought we would take a look at the challenges that people face when trying to enforce marks that are of low distinctiveness. And 2025 has continued to show that even if a mark is registered, if it has a low level of distinctiveness, it might not give brand owners the monopoly that they hoped for. So what do we mean when we say marks with low distinctiveness? We mean trademarks that are perhaps considered to have a very weak ability to distinguish the goods and services of one company from another, perhaps because the words included in the mark have a descriptive meaning or an elusive descriptive meaning, or because they're made up of commonly used words in a relevant industry that many other businesses use. So they're not wholly unique. Next slide, please, Jane. So probably the easiest way to show this is to go through some examples. One recent example involved Easy Group, who are notoriously litigious and commence trademark infringement action against various businesses regularly every year. This one involved them going after Premier Inn, who had started using the words "rest easy" in their branding, and there's a couple of examples of how they were using it on the right hand side. And Easy Group sought to sue them for trademark infringement in part based on a registration they had for Rest Easy apartments. And then they argued there was a likelihood of confusion because of the identical words Rest Easy featuring in both Premier Inn's marks they were using and the mark they had registered. Um, they failed on this ground, because the court did not consider that Rest Easy would be seen to hold independent, distinctive character within Rest Easy apartments, and they considered that the average consumer would not understand the words Rest Easy appearing in the sign as being the entirety of the Rest Easy apartments UK trademark. So clearly there was an issue here where the mark was of such a low level of distinctiveness that really it only gave them protection for preventing use of marks that were identical or pretty much near enough. And the way that Premier Inn were using it was just not close enough to be an issue. Next slide, please, Jane. So another example involved Google and their YouTube brands, and they sought to sue a business called Shorts International for trademark infringement and passing off based on their use of Shorts and Shorts TV. And there's some example of the relevant marks on the right-hand side. Their claim also failed, because the court held that the words shorts and a play symbol were individually non-distinctive. They held that the distinctive character of the Shorts International marks arose from the combination of those very specific elements all together. And because that identical combination was not present in Google's registered marks or their usage, there was no likelihood of confusion. So, again, it's showing the issues with low distinctive marks. And here, even though they had registrations, it did not confer on them an ability to police any and all usage of the word shorts in the relevant sector, and it gave them a very limited ability to do so. Next slide, please, Jane. So finally, we also thought we'd take a very quick look at low distinctive marks, even where they have a reputation and the issues that that can bring. Now, this case had a number of issues, admittedly, but I just wanted to take a very brief look at it in the context of low distinctiveness. Adidas had sought to sue Tom Brown for using a four-stripe design on clothing in various positions. There are a couple of examples on the right-hand side at the bottom. Adidas owns various trademark registrations for their three-stripe design in a number of positional marks, so where they've registered the mark for a particular position on clothing in a particular style. Their claim failed, and it probably failed due to a number of issues. But in this context, I think it's worth noting that the judge only considered there to be low levels or very faint levels of similarity between the majority of Adidas's registered marks, such as those positional ones on the jackets to the right-hand side, and the way in which Tom Brown was using the four-stripe design. And it was also notable that the absence of any evidence of actual confusion really hurt their case. So I think the key point really to take away from that is that, it is inherently a fairly simplistic design, a three-stripe device, and therefore it does not inherently obtain a wide scope of protection. But even with a huge reputation such as Adidas, which they were able to demonstrate to an extent, it wasn't enough to be able to stop Tom Brown using a four-stripe device. Was it to be a question of more unique designs or more complex graphic elements, then maybe the issue would have been decided differently. But quite clearly, a three-stripe design on its own inherently is of quite low distinctiveness. Next slide, please, Jane. So the key takeaways really are probably more practical ones for enforcement, and that whilst it might be possible to register marks that have descriptive elements or not non-distinctive or commonly used words or graphic elements, even if you do register them, it's probably going to be very difficult to enforce them widely, and the scope of your protection is probably only going to be to identical marks or ones that are near identical. And so, from a practical perspective for businesses, if you do want to obtain a strong monopoly and you want to be able to police the market quite widely, then perhaps aim to develop as unique and distinctive a brand identity as possible. So I think that brings us into the final section of the webinar, Jane, if you'd like to take us in.
Okay. So there are other topics that have been in the spotlight this year, and we're just going to run you through those. So the first one on the list is that series marks are to be abolished. Although it is still possible to apply for them, at this current time. Um, Service marks are going to be discontinued. In terms of timeline, we don't have the exact date for this. We're just told it could be autumn, winter 2025. So basically, anytime soon. Um, if you do have series marks in your portfolio, that's fine. All existing series mark registrations will remain valid. So the takeaway in terms of series marks is that if businesses wish to register series marks, you should do so promptly before they are discontinued. Moving on to green claims and sustainability marks. So these are always in the press. You may have seen recently an issue with the Red Tractor certification mark, which was found by the ASA to be making claims it could not substantiate. So to avoid misleading advertising risks, the key takeaway here is that if you're using certification marks, that's great, but be clear what they stand for and ensure that you don't make broader claims unless you can substantiate them.
And finally, we just want to take a very, very quick look at a recent decision that concerned licensing and royalty arrangements in the Alaska Airlines and Virgin Aviation case. And the court in that decision confirmed that minimum royalty obligations under trademark licenses can persist, even if the brand that's the subject of the license is no longer being used by the licensee. Um, as a very quick bit of context, Alaska Air Group acquired Virgin America in 2016, and they merged their operations in 2018. And the Virgin brand name was phased out. And at that point, Alaska stopped paying royalties under a previous licensing agreement that had been agreed, and that they considered they were no longer obligated to do so because they weren't using the brand anymore. But Virgin argued that the wording of the trademark licensing agreement was such that there was a flat fee payable until 2039, regardless of whether that right was actually being exercised. And the court agreed and rejected Alaska's argument, and they've been ordered to pay more than 30 million US dollars in missed minimum royalty payments. So I think the key takeaway there is just be careful on the wording of your licensing agreements. Make sure you're aware of what you're signing up to, and carefully draft any obligation clauses to anticipate long-term arrangements and have a good exit strategy in place. So that brings us to the end of the webinar, and we open up the floor to anyone with any questions.